This hearing is being conducted via Zoom. Are you Dominic McNamara?
Yes.
Okay, is Jenna Roberts present on audio? It appears that Ms. Roberts is not present. She was present on October 29th, which time she was advised that this matter would be reviewed by this court today, December 10th at 8:30 a.m. It's now 9 a.m. Ms. Roberts has not appeared. She's not contacted the court. Obviously, she did appear with the minor child at the time of the DNA testing. Mr. McNamara, you went to the courthouse on November 7th for the testing. Is that correct?
Yes, sir.
And Miss Roberts was there with the minor child, Blake?
Yes, sir.
Okay, so you saw her there. Was there any discussion between you and her about this court date?
No, we did not talk at all, but I did see her and her family though.
Okay. Did you make an effort to contact her this morning to remind her of this court appearance?
Yeah, I texted her through text message, but she has me blocked, but I had sent a text to her mom, the same thing with the user ID, and that went through, but I don't think I've heard anything back yet.
Your Honor, I also did reach out to Ms. Roberts on the phone number listed on the summons. It went to voicemail. I did leave a voicemail that she did miss her hearing at 8:30 this morning and to appear.
Thank you, Ms. Brower. For the record, that's Ms. Brower for the front of the court. So reasonable efforts have been made to remind Ms. Roberts of this court date. In any event, the court is in receipt of a DNA test report from DDC dated November 14th, 2024, indicating that the alleged father, Dominic McNamara, as well as minor child Blakely, both submitted DNA samples, and the results of the test is there's 0% probability of paternity. Mr. McNamara, why did you sign an acknowledgement of paternity on July 29th?
Pardon me?
Why did you sign an acknowledgement of paternity on July 29th, 2024, after this child was born?
Well, I was kind of led to believe that she was mine, and we were kind of in a relationship for little under a year beforehand, and so I kind of just believed everything going up until we did a net home test and then went forward.
Very well. Ms. Brown, do you know, as Ms. Roberts, is she receiving public assistance for this child?
I do not know that, Your Honor.
Okay. In any event, even though Ms. Roberts did appear back on October 29th, 2024, she has not filed an answer to the complaint seeking to revoke paternity. She's not appeared today. Accordingly, Mr. McNamara, the court will grant the relief requesting. The court will enter an order revoking paternity. It's unfortunate we have Ms. Roberts here, so we can determine who the biological father is. But you represent yourself. You need to submit to the court an order.
Pardon me? What was the last part?
You are representing yourself, so you need to get an order, prepare an order to the court to sign revoking paternity. You went online, got these forms, a complaint, revoke paternity and so forth. Wherever you got those forms, did you get those online?
The revoke the paternity.
Mr. McNamara, wherever you got those forms, you got to go back and find an order revoking paternity. You need to submit that to the court.
Okay, yeah. Yeah, I'll have to send it to the court, you said?
Well, deliver it.
Okay.
I mean, the court speaks through its written order, so you need to submit it this time. The court will grant your the relief you are requesting. The court will enter an order determining that you are not the biological father of this child, and the court will revoke paternity. But you need to prepare that order and submit it to the court for signature. This will not be concluded until you do that. Do you understand that?
Yep.
need to do that as soon as possible, and hopefully within the week.
Okay. All right.
Probably should have gotten that together once you got the DNA test results.
Yeah, it's probably sitting in my room. I was just unsure of that.
Okay, and you still live in Gibraltar, is that correct? Still at 291? All right. Mrs. Brower, I suppose you could advise prepare in front of the court order, but I think we also need, Mr. McNamara needs to submit a SCAO order, revoke maternity. So once again, Mr. McNamara, the court will grant the relief for requesting. Do you have any questions?
Like just the name of the two orders that I have to turn in.
Well, it's just one. It's an order revoking paternity.
Oh, I thought you just mentioned another one. I apologize.
I think Ms. Brower is going to simply prepare just a notation for the court that the court is granting your motion to revoke paternity, and that you'll submit an order revoke paternity. So we need that. It needs to be done in your part since you're representing yourself.
Okay. All right.
So court will look forward to receipt of that in the next, hopefully, we certainly want to do it this month. Let's get it done. Close out this file.
Oh yeah, I want to get it done as soon as possible as well.
All right. All right. That will conclude this matter, Mr. McNamara. You can zoom out.
Oh, okay.
Do you still have a relationship with this Miss Roberts at all?
No, I have not talked to her since I have gotten like the first set of results back. We talked a tiny bit, but there was nothing good coming out of that. So,
okay. All right. That will conclude this hearing. You can zoom out. I guess we're ready to go then. Good morning, Ms. Brower. For the record, this matter is before the court for the purpose of reviewing parenting time. This hearing is being conducted via Zoom. Present is Attorney David Carson, representing the plaintiff father, William McLaughlin. Mr. McLaughlin appears to be present with Mr. Carson. In addition, Attorney Timothy Churchill is present, representing the defendant mother, Misty McLaughlin. Ms. McLaughlin appears to be present with Mr. Churchill. Good morning, everyone.
Morning, Your Honor.
Parties have conferred with Mr. Walker in front of the court this morning. Mr. Walker's recommendation is as follows. Mr. Haskins, the therapist for the children, has not and will not provide a list of reunification counselors at this time. The parties and the minor children are on a list at Downriver Family Connections and Wyandotte for supervised parenting time. There has not been a supervised visit yet. Supervised visitation at Downriver Family Connection shall continue, and they shall provide written reports in front of the court regarding supervised visitation once the visitation commences. And further, that the parties appear back for this court to review any outstanding issues, particularly parenting time, for plaintiff father on February 25, 2025 at 9:30 a.m. via Zoom. That is a recommendation. Apparently, the court's informed that Family Counseling and Shelter Services will not supervise dad's parenting time. So as an alternative, we are going to explore parenting time, supervised parenting time for dad at the Downriver Family Connections. Is that correct, Mr.
Correct.
Carson?
That is correct, Your Honor.
Do the parties both, I guess we need a phone number. Both parties need to contact the agency to schedule an intake. Does anyone have that phone number?
Yes.
They have that, and they're both on the list to be scheduled for the
Oh,
intake.
good. Oh, wait, was there any idea of the time frame for the waiting list?
They said after the holidays.
They said it will most likely be after the holidays because of how busy they are
Short work weeks.
and short work weeks.
Well, I can understand that for the week of December 23rd, but hopefully they can schedule some of the week of December 16th to next week. So the court will encourage both parties to call and try to see whether they can make it. If there are any availability, the court would order that the parties cooperate. Obviously, the court wants to reunify, have spent some time with his children as soon as possible. So Mr. McLaughlin, call the agency, see whether they can squeeze something in between now and the end of the year. And if so, then Mr. Carson can call Mr. Churchill, and Mr. Churchill, the court would expect Mr. McLaughlin would comply with that opening, availability, and transport the children. With respect to the prior order that Mr. Haskins was to provide a list of reunification counselors, the court is informed that Mr. Haskins does not believe reunification is appropriate at this time, but he still sees the boys on a weekly basis. Is that correct?
Correct.
For that reason, he would not provide a list of reunification counselors. Mr. Carson, is this recommendation good with your client this morning?
Yes, Your Honor.
Mr. Churchill, is this recommendation good with your client this morning?
Yes, Your Honor, and the issues we just talked about, we have a few other issues too that aren't addressed in there, so.
Okay, one issue, I do note that a motion for finding contempt was filed. I don't know if that was noticed up for today. It had to do with the insurance card that for the children that was not provided within 24 hours. Is that one of the issues that needs to be addressed?
Yes, that is one we need to address.
Okay.
On,
When did your
if
client
you want to
ultimately receive
address
that?
it now, we'll do it one
Yes.
at a time.
When did your client receive that card, Mr. Churchill?
My client received the card on Friday, right, the December 6th, right after I sent the motion to his counsel to hold him in contempt for not providing it in 24 hours. You were
All
pretty
right.
specific when you told him that. And we got a health insurance card, but there's no information on there about the dental coverage they had or the vision coverage, which was through another company. And again, we were in court November 12th. You were pretty clear when he had to produce that. And this is just reflective of how he cooperates in regard to any issues.
All right, Mr. Carson.
Yes, Your Honor. So I did not, just for the record, I did not receive the contempt motion in the mail until Monday. So I didn't even know there was a motion filed. There was no notice of hearing with the motion. So there was no response filed. However, my client was very hesitant to provide the card because there's been some past history of Ms. McLaughlin contacting my client's employer, and she would know where my client worked if she did receive that card. However, after talking with my client, he did give me the copy of the card. It has been provided to Ms. Kuhn. So I believe that Ms. McLaughlin does have a copy of the card right now.
Mr. McLaughlin was ordered to provide that to you as his attorney within 24 hours. Did he do so?
Yes, Your Honor.
Okay, so you failed to pass it on to Mr. Churchill and Ms. Kuhn. Is that the situation?
Well, he did provide the card to me. However, he was very reluctant to have me send the card for the reasons that I previously stated, Your Honor.
Okay, but what did this court enter an order on November 12th that father was to provide his insurance card to his attorney within 24 hours?
Yes.
Okay, so he did provide that to you, but you failed to forward it to Mr. Churchill and Ms. Kuhn. Is that correct?
That is correct.
Did you communicate with Ms. Kuhn and Mr. Churchill advising of the concerns?
No.
All right. Okay, so obviously it was not provided within 24 hours. It was ultimately provided. Do you have all the insurance cards, Mr. Churchill, now? Do you have the insurance card for?
We have nothing on dental and nothing on vision. We have the regular insurance card.
Okay. What about them, Mr. Carson? Are there different insurance companies, or does that one card cover?
Yeah, it's a different
optical
company.
And dental?
So, Your Honor, my client did start a new job. He has not received any dental or vision insurance cards yet. When he receives them, they will be provided as soon as he gets them.
When he received those, is it within what, 60 or 90 days of his new employment?
I have no idea.
I don't believe my client knows, but like I said, he has not received them. He is going to look into it, so we are not withholding anything, Your Honor.
Well, again, obviously, unless we establish a time frame, it'll never be received. Mr. McLaughlin should know when his benefits begin. He has no idea. He's never inquired what he's got when he has dental or optical insurance.
Benefits have begun. I just haven't received the card in the mail yet.
I don't know if you heard him, but he said the benefits have begun, but he's not received the card in the mail yet.
Okay.
He's with the same employer, Your Honor, and he's got the health card. I'm sure he's got the other cards too. And there was no explanation stating, hey, there's other cards forthcoming or anything. He just doesn't cooperate. And when he does,
I'm going to give him the health
it's
insurance.
months later and partial compliance.
Your Honor, the medical card was provided. He has no problem. I've had many conversations with my client about providing this information. There's no problems going forward. He does not have it. When he has it, he will provide it. So let him at least go speak with the HR person at his new job that when did you start it?
July.
In July.
End of July.
End of July, and he will get a copy of it and provide it. But
Okay,
he does
so
not have it, so he cannot provide it.
Well, but he should call. He should call in and get that card. Obviously, I mean, if he started this new job in July, he should have them by now, but then if he's not, he should call them. So the court wants to establish a date by which he'll provide those cards to Attorney Kuhn or Churchill. Well, what day can, he should call the HR department today and tell him he needs those cards. He needs dental work. I mean, the mom should have that for the children. I don't know when the children last had a dental appointment. So, Mr. Carson, when can we, just put in this recommendation, a date by which he'll provide the optical and dental insurance cards?
30 days, Your Honor.
About by the end of the year.
Okay.
I'll try.
Yeah, we'll do our best.
Mr. Walker, if we can add this recommendation that the plaintiff will provide to mother through his attorney the optical and dental insurance cards for the children prior to December 31st, 2024. Mr. Churchill, the court recognizes there was obviously a delay. Mr. McLaughlin apparently complied with the order. He provided his attorney with the card, but then the attorney did not provide that to you. Did the children, was there any healthcare services rendered that were not covered by insurance because of the fact that Ms. McLaughlin had not received that card by December 6th?
Yes.
Yes.
I had to pay for
Okay. What does she have documentation of those medical appointments?
She has
Yes.
prescriptions out of pocket she had to pay for. And, this is what she always does. And then she sends her the bill and he never pays her back for what he's
Yes.
supposed to pay.
Your
Okay.
Honor, I'm sure there's a copay. My client has been in contact with the pharmacy and the children's doctors. There's no outstanding medical bills. And if there is a copay, that should be covered by the ordinary medical. So
Not when you don't have a card and you can't tell them who.
I'd have
Hold on,
to
Mr.
see-
Churchill, hold on, Mr. Churchill, let Mr. Carson finish, please.
I have to see some documentation, Your Honor, but according to my client, everything has been covered.
There is outstanding bills.
All right.
There's outstanding bills.
Urgent.
All right, the court will reserve, and we can address on February 25. The court will address any unpaid medical expenses. So Mr. Churchill will provide documentation to Mr. Carson and to the front of the court, and we can address that on February 25 if it's not covered by ordinary medical. And again, the court's can order that the plaintiff father provide to defendant mother's attorney the vision and the optical and dental coverage cards prior to December 31st, 2024. So that will address that issue. And if in fact there was a out-of-pocket cost that was unnecessarily incurred, we can address that on February 25, Mr. Churchill. What other issues, Mr. Churchill, do we need to address today?
Well, and again, I just want to state on the card, Your Honor, your order further said that he shall provide our office a copy of the card when it's received. So he elected to sit on it for almost a month before we got it. And again, that motion was emailed to him on Friday. Within hours, we finally got a copy of the card. I'm just livid. He never does what he's supposed to do. And his attorney doesn't do what he's supposed to do. The other issues deal with the discovery that we sent him back in August and September, which we finally got answered on December 9th. And of course, the answers were a joke. They're incomplete. And we'll get into the sale of these cars. He was supposed to put these cars up for sale on January 1 of 23. Here we are 2 years later, and he claims he sold the vehicles, the Focus, the 2012 Focus, for $500 and $2,000. And the person he sold it to was Sarah Lang, who's his girlfriend, and a Robert Badilla, who's his girlfriend's son. Same thing with the other car. Oh, he sold them back in May of 2023 and sold them both for a loss to his girlfriend. There's no evidence title's been transferred or anything here. It's just a
Mr.
joke.
Churchill, you can notice those up. Once you notice those up for hearing on February 25 at 9:30, let's deal if there's some post-judgment property issues. Notice those up for hearing. We'll address those on February 25, 9:30. We're coming back to address parenting time.
Okay, well, if I can at least address the discovery answers that were due months ago, ordered to produce them by the 12th of November before, ordered to produce them again. We finally got them December 9th. We got them a day before the hearing.
Okay.
They were due months ago, ordered to be produced on a motion to compel. We filed 2 motions to compel. His attorney never timely answered those either. We
You've
keep
now
coming
received
back
them.
to this.
Even though they're late, you've now received them. Is that correct?
We never received him. He was ordered to produce them by the last hearing on November 12th. He didn't do that.
Your Honor, if
We
you look at,
waited another month.
Your Honor, first up, Mr. Churchill's comments are highly offensive. I want to share my screen and share the email that I received from Kim. There was no motion attached to it, so if the court would like to go into that, we can. I received the motion on Monday in the mail only. And if you look at the order, it says nothing about a due date for the discovery. They've been provided, they have been satisfactorily complied with. I have no idea what Mr. Churchill is talking about. He just makes these wild statements without any specificity at all. So this is completely ridiculous, completely offensive. Mr. Churchill is not being professional in the least. And also, there is another issue about the app close calendar that's still not being followed. She lied to Mr. Walker during the hearing with friend of the court, and we have pictures, we have a roster to show that the son is in soccer. He played in the game. We have pictures of it. So if we're going to go into all of this, then I guess we have to go into the soccer stuff too. But this is completely ridiculous, Your Honor.
Okay. Well, the court just will reemphasize the parties must use app close. And obviously, if they're going to hear you now, then people are going to print out those app close communications. The court will take action. But let's just, Mr. McLaughlin, all communication via app close, please. As previously ordered, the court will once again reemphasize all communication shall be via app close and regarding the children. With respect to discovery, Mr. Churchill, you're saying the discovery is incomplete. Is that correct?
Well, Your Honor, I want to point out, I just need to address what he said. Your order on September 24th said Mr. McLaughlin shall provide discovery answers to his attorney who will provide that information to Mrs. Kuhn within 14 days. That's what we finally received on December 9th, what he was supposed to do back in September. And to refresh opposing counsel's recollection, there was also a motion for sanctions filed in October on this issue about you not timely answering discovery. And I'm not imagining this. I have a stamped copy of it from the court.
Your Honor, I'm looking at the last order dated November 12th. There is no due date. It says the show cause proceeding regarding discovery and defendant's failure to add items to the shared app close calendar shall be heard December 10th, 2024. So they filed a motion to compel. Allegedly, it was not complied with. So there's a show cause hearing on the matter. Discovery answers were provided. Mr. Churchill is being extremely petty. He has some hostility toward me and my client. He has the answers. He has everything that he needs, Your Honor. This is a waste of time.
Okay, has discovery now been completed? Even though it's been late, Mr. Churchill, have you now received the requested discovery?
Finally, months later, if you look at the court's order on September 12th or September 24th, it specifically states Mr. McLaughlin shall provide the discovery answers to Ms. Kuhn within 14 days. That was back in September. And there's a court order in here that you signed on September 12th in that regard. I don't know what
Have you now received the discovery?
Finally, months later, and after having to file motions to compel, we shouldn't have had to file. And then we find out he's never sold the vehicles.
Your Honor.
Well, that's duly noted that the discovery was late. Was there a motion to compel that was filed, Mr. Churchill?
Yes, there was. There was also a motion for sanctions that Kim filed that's clocked in.
Okay, what are you asking for, Mr. Churchill? What's your request?
July 29th, attorney fees for having to repeatedly file motions and make requests for documents that should have been provided a long time ago. Kim provided a statement in the court file for $470 back in October, and we're still coming back on this
Your Honor,
issue.
respectfully, the court already ruled on that. There's been an order entered since the September order. So if someone doesn't comply with an order, you show cause them and ask for sanctions then. So today's the show cause.
You know,
the discovery has been
continued to give you additional time to do it.
Your client is not complying with the order either. Do we really want to get into this?
My client complied with the order. Your client got an
not.
app close message.
She did not.
She
did not.
You took months to get this stuff
Mr.
out, just like
Churchill,
you get the insurance card and the court tells you to give it to us and you decide to sit on it. All I'm asking for is cooperation here. Jeez.
Your Honor, he has
Can't get
everything he needs.
client
He's
nor
being
counsel.
extremely petty. He wants to waste the court's time. He wants to run up his client's attorney fees. He is extremely unprofessional. He's extremely insulting. This is completely ridiculous, Your Honor.
And you are extremely non-compliant.
Mr. Churchill, before your office filed the motion for finding of contempt for failure to provide the insurance card, did you communicate with Mr. Carson asking where's the insurance card? Was there any communication, email or letter?
Your Honor, can I share my screen?
I'm just simply asking, obviously, Mr. Carson, you've already stated that you did not provide it once you received from your client. I'm just asking, did you receive a demand or request from Ms. Kuhn or Mr. Churchill for that insurance card before they filed the motion?
I received an email on December 3rd stating, please have your client contact Downriver Family Connections, and it says the phone number to set up an intake for supervised visitation. I also want to remind you that we never received the insurance card that your client was supposed to provide. When can we expect it? It was sent to her on Monday, December 6th. So there was no motion attached to the email, as Mr. Churchill has falsely stated already. So
December 6th was a Friday.
I've done my invitation.
When was the email?
So I got the email December 3rd, and then I sent everything.
Tuesday.
Yeah, sorry. So I sent everything on December 6th. They've had a copy of the card since December 6th. I've already addressed it with the court, so I'm not going to restate what I already said.
Right. Did you respond on December 3rd or December 4th?
No, I responded on December 6th. I said, please see attached, and I have a copy of the.
Okay, well, again, in the meantime, Ms. Kuhn, because she didn't hear from you, filed a motion to find contempt dated for December 5, 2024. And that should not have been necessary had you promptly responded, Mr. Carson. I understand you've got a lot going on, a lot of emails, but that should have been, they should not have had to file that motion. So the court will order that Mr. McLaughlin pay $300 in attorney fees to attorneys Kuhn and Churchill. That $300 shall be paid on before December 31st, 2024. If you can add that to the recommendation, Mr. Walker.
Your Honor, what's that $300 based on?
Based upon that attorney, and I'm sure they billed their client more than $300. Ms. Kuhn filed a motion for finding of contempt for failure to provide the insurance card. And that was dated December 5, 2024. That would have been unnecessary had you timely responded to the email asking where the insurance card was.
Your Honor, I responded 3 days later. I would say that's timely. I'm not at my desk all the time. I don't have time to sit here and respond to emails every second they come in. They're provided 3 days later.
They should have been provided within 24 hours, as the court says, contrary to this court's order of September 12th, 2024. So that is ordered to be paid on for December 31st. We'll review parenting time on February 25 at 9:30.
Your Honor.
And parties shall use AppClose for all communication. We'll reemphasize that.
Your Honor, there's supposed to be a show cause hearing regarding Ms. McLaughlin's failure to provide dates on the AppClose calendar. So you're going to sanction my client, but we're just going to ignore her violation?
All right. Okay. What I was not, hold on. I was not aware there's a show cause hearing except for today on the AppClose.
Yes, there is.
Okay. Okay. And it's your position that, how much you're requesting, Mr. Carson?
No.
We're going to request $500, Your Honor.
For what?
Tax from
For the motion?
For communications, attending these hearings, all of that, Your Honor.
Did you file a motion for her to show cause alleging violation of the AppClose communication?
Your Honor, I don't understand why I have to file a motion if the order already states that the show cause proceeding is going to happen on this day, Your Honor.
Did your client incur unnecessary attorney fees because of that alleged failure?
Yes, Your Honor. I keep having to appear at these hearings and then address these outstanding issues.
Right. All right. So Ms. McLaughlin shall pay $300 to Mr. McLaughlin on before December 31st. Each can pay each other $300. And that will address and resolve those issues. And the quote puts back on our docket February 25, 9:30 a.m. Mr. McLaughlin, communicate.
Your Honor,
You're incurring a lot of unnecessary expense and issues for your children.
Your Honor, in light of
Right, can you add a couple of those two things, Mr. Walker? That will conclude this hearing. The copies will be mailed out to counsel.
Your Honor, just real quick, in light of the offsetting attorney fees, can we just agree not to pay each other? It's just a waste of time.
He didn't
I'll leave that
order.
to you, Mr. Churchill.
Your Honor, I thought you said Mr. McLaughlin to pay to Mrs. She has
Correct.
the app closed.
Each will
Yes,
pay
it is.
$300 to the other for attorney fees unnecessarily incurred. If you want to zero it out, I'll leave that to council.
Yes, I have
Okay,
no
what
problem.
I'm asking the court, did you order her to pay him attorney fees? I don't think you did, so there's nothing to offset.
Yes, I just did. Each will pay the other attorney $300 before December 31st.
Here's a text from Coach Johnny that says.
I have the
I'll
app
include this
closed
matter. Everyone can
message
zoom
here.
out.
Oh, Jesus. Okay.
For the record, this matter is before the court for the purpose of reviewing defendant mother's parenting time. This hearing is being conducted via Zoom. Present is attorney John DQ representing the plaintiff father, Christopher Lockwood. Mr. Lockwood appears to be present with Mr. DQ. In addition, defendant mother Taylor Kinsel is also present. Good morning, everyone.
Morning, Your Honor.
Parties have conferred this morning with Ms. Brower from the front of the court, who has provided the court with the following recommendation that mother should have a supervised parenting time on Tuesdays from 12:30 p.m. to 3:30 p.m. and Fridays 4 p.m. to 7 p.m. Tuesdays shall be supervised by the plaintiff's mother. Fridays shall be supervised by the defendant's mother. Defendant's mother shall transport on Fridays. If mother's work schedule allows for a Sunday visit, the parties shall agree upon times for mother to have supervised parenting time on those Sundays by either grandmother. Further, defendant mother shall have holiday parenting time on Christmas Eve from 3 to 7 p.m. supervised by her mother, namely the maternal grandmother. The parties will attend the scheduled visitation today at Family County Shelter Services and commence the above referenced schedule on December 13th, 2024, which is a week from Friday. There should be no social media posts regarding the other parent or the minor child. Neither party shall use alcohol or any drugs, mind-altering substances prior to or during parenting time. There should be no discussion of this case with the minor child. And all communication between the parties shall be via app close and only regarding the minor child. Finally, the parties will appear back for court to review mother's parenting time on January 14th. It's a Tuesday, 2025 at 3 p.m. via Zoom. That is the recommendation. Mr. DQ, is this recommendation given with your client this morning?
It is.
Ms. Kinsel, do you understand the recommendation?
I do.
Objection to the court adopting this recommendation?
What?
Do you have any, are you agreeable with this recommendation?
I would like to state that I did ask for more. I did ask for 50-50 custody back, but Mr. Deku is not comfortable. I do agree.
Okay. Well, we're going to move slowly. You are still actively engaged in mental health counseling. Is that correct? Ms. Kinsel, are you still actively involved in mental health counseling? Ms. Kinsel, can you hear the court? Ms. Kinsel, can you hear the court? She apparently cannot. Mr. DQ, have you received any recent reports verifying that Ms. Kinsel is actively engaged in mental health counseling?
There was a letter from Dr. Ahmed, who is her psychiatrist, who she sees at Harbor, that was delivered to friend of the court this morning and shared with me by friend of the court. So at this point in time, it does appear that she's compliant with the requirement, that mental health professionals' requirements.
All right. Thank you. Ms. Kinsel, can you now hear the court?
I cannot hear. My volume is all the way up. Hello?
Yes. Can you hear the court?
Yes, now I can.
Okay. The court was making inquiry whether or not you are actively engaged in mental health counseling, and you did not respond, so you couldn't hear. But Mr. DQ has indicated you have. They recently received a letter, so the court would encourage you to continue the mental health counseling, and hopefully you can make progress so we can get back to some unsupervised parenting time when we come back in January. That's the whole goal here.
Yes.
Mr. DQ, do you need to voir dire your client regarding this recommendation?
No, I do not. There's one thing that is not part of the order, Your Honor, but it should be made part of the record. And there's an invitation to Taylor to go over to Chris's house Christmas morning for a couple hours if she would like to participate in the Christmas morning things, but it's not part of the order.
Okay, and perhaps Mr. Lockwood can communicate via app close regarding that, just to again encourage that and remind her of the date and time of that invitation.
Yes, sir.
All right. All right. The court will adopt the recommendation. Copy mailed out to everyone, and we will see you, Ms. Kins, on January 14th at 3 p.m.
Very good.
All right. Thank
Merry
you.
Christmas, Your Honor.
Thank you. Same as you. Everyone can zoom out. Have a good rest of the day. Thank you. For the record, this matter is before the court as a result of the defendant's objection to entry of a proposed judgment of divorce prepared and submitted by the plaintiff. This hearing is being conducted via Zoom. Present is Attorney Maria Zagorski, representing the plaintiff, Mark Mansick. Mr. Mansick is present. In addition, Attorney Eric Chappell is present, representing the defendant, Rebecca DeVoot, and Ms. DeVoot is present. Good afternoon, everyone.
Good afternoon.
I'm sorry, Ms. Kuhn is also present. Ms. Kuhn is co-counsel with Mr. Chappell. Is that correct?
Yes, Your Honor.
Is that correct? Ms. Kuhn, you're co-counsel?
Yes, Your
with
Honor.
Mr. Okay, yep,
I
I
am.
thought so. Thank you. Okay. Via the pleadings, the court was not able to grasp what the issue and dispute was, and you conferred with the front of the court this afternoon and have not reached an agreement. Is that correct?
There are two outstanding issues right now, Your Honor, that the part that we have not agreed on. I think we've resolved all other language issues.
What are the issues? They've not been set forth in any of the pleadings.
Well, Judge, we've been shuffling a proposed judgment back and forth. We did get the transcript. We've gone through it page by page. And as Mr. Chappell indicated, there are just two issues that we would like the court to determine. And I'm happy to start with the easy one first, Judge.
Yeah.
The parties are required to communicate by app close. I have asked that the communications be civil and respectful and that the judgment state as much. And for some reason, the defendant does not want to consent to language that would require the parties to be civil and respectful. That's the easy one.
Well, obviously that's implied. It should be civil and respectful. Mr. Chappell, who's going to respond? Mr. Chappell or Ms. Kuhn? Why?
Your Honor, I'll be happy to
your opposition to the
respond.
words civil and respectful?
Yep. The concern is we're creating something and putting something in a judgment of divorce where someone then has the ability to come to court and make an argument that, you weren't civil, you weren't respectful, which are very subjective determinations, and therefore try to hold someone in contempt of court. It may seem unorthodox, Your Honor. We'd like to all believe that the parties are going to, always be civil, always be respectful, but this is a case where we couldn't even agree on what the definition of summer meant. So the concern is that it will just be one more avenue for Mr. Mansick to come in and say, I don't think you're being civil. I don't think you're being respectful. And then the court has to determine what those terms actually are.
Well, I think this court can use common sense and determine whether something is civil and respectful or not. I don't think it requires a legal determination or judicial determination. It's simply common sense.
Yeah. And understand that would be the standard always, Your Honor. We're just trying to avoid avenues where it will create further litigation.
Well, perhaps the best way to avoid that is to spell it out. So yes, the court will approve putting the words civil and respectful communication by app close.
Thank you, Judge. The other issue is as to custody and parenting time, and I'm sure you have a copy of the transcript in the file. You'll recall this was a little unorthodox. The parties wanted to get divorced and they were waiting for a report and recommendations from Dr. Wooten. And for that reason, we put an agreement on the record making custody and parenting time subject to Dr. Wooten's report and recommendations. That if Dr. Wooten issued a report or made recommendations, that either party could come back and that report would constitute proper cause or a change in circumstance, and either party could ask for this court to make a different determination about custody and parenting time other than joint, which is what they were exercising. Initially, defendant's counsel wanted the judgment to say that the custody and parenting time were temporary and without prejudice. And I was uncomfortable with the word temporary because I didn't think a judgment could say that custody and parenting time were temporary, but we ordered the transcript and counsel was right. The agreement was that custody and parenting time would be temporary and without prejudice. Today, counsel is asking to insert that custody and parenting time are reserved. and I take exception to a judgment of divorce reserving custody and parenting time. I think a judgment of divorce has to decide custody and parenting time. So we looked at the transcript, and the basis for their use of the term reserved was your honor's use of it when you called the case and announced that there was a settlement. You stated, and this is at page 4 of the transcript at the bottom, Mr. Godfrey has informed the court that the parties have reached an agreement on all outstanding issues with the exception of custody and parenting time and wish to reserve that issue until receipt of Dr. Wooten's custody and parenting time evaluation. Is that correct, Ms. Zagorski? I said yes. Ms. DeVoot's counsel said yes. And then Mr. Godfrey put the agreement on the record, and he said custody and parenting time are temporary and pending further order of the court without prejudice. That is the language that the parties approved, temporary and without prejudice. The court's use of the word reservation, or that it was reserved, I don't think was intended to bind the parties. And my client didn't intend for that issue to be reserved, nor did I, even though I did say, yes, Your Honor. And so the argument is whether custody and parenting time are reserved or temporary and without prejudice.
Well, perhaps the court inappropriately used the word reserved. I just knew that there was not a full and final agreement on custody and parenting time. So I think it's more appropriate that the judgment provided as temporary and without prejudice.
Thank you.
So in other words, when Dr. Wooten, if he submits his report, the parties can come back before this court.
Well, and the problem with that, Your Honor, is that's not the limit of what the parties agreed to. So now we're going to have to get into other language because Mr. Godfrey also made it clear, and this is why it was reserved, and this is why we think that the words are important. Mr. Godfrey made very clear on page 5 of the transcript that you could come back in for a change of circumstances for Dr. Wooten's report, okay? In addition, if you look at pages 17, 18, and 19, neither party is prevented from bringing up matters or actions or acts that they think is important that predates this agreement. That's why reservation is important. If we don't have the words reserve in there, then we need to include the language in there that everything is open. Because here's why we believe it's important to the plaintiff. We're going to hear an argument down the road that, once a motion to modify is filed, because there is one coming, that there's certain things that you can include and there's certain things you can't include. So the reserve language, which was what the court asked at the very beginning, signifies that it's open, it's wide open.
The problem with, I'm sorry.
And we don't want to limit, anyone's consideration of what occurs just based upon Dr. Wooten's report.
The problem with Mr. Chappell's argument, Your Honor, is that I have approved language that says the parties stipulate and agree that when Dr. Richard Wooten's report and recommendations are issued, that Dr. Wooten's report is sufficient and adequate grounds for either party to seek a modification of parenting time or custody. Accordingly, this judgment shall not operate to stop either party from raising any issue that predates the judgment of divorce as part of a party's request to change custody or modify parenting time. So Mr. Chappell's requested language is already in there. It was in my original draft. I just don't think that the custody and parenting time provision should say reserved because this court used the word reserved when that's not what the parties agreed.
But that was the predicate of the agreement. It was the first thing we said when we came into court.
And
That's what the court said. That's what the court said.
But Judge, we confirmed that that's what our intent was.
The clients did not.
Well, they were next to us. I mean, it's hard to say that the clients didn't confirm it when they're sitting right next to us and we're speaking on their behalf.
I don't, Judge, I don't think that you were speaking with any intent to bind the parties. You were calling the case and introducing what you understood to be the situation. And then Mr. Godfrey read the agreement into the record and the parties confirmed their agreement.
Your Honor, do you have the transcript by chance?
Yes, I do. And I think I'm going to have the parties brief this issue. I'm asked to look at page 5 and 17, 18, 19. I'm trying to grasp because this court did not play any part in the negotiations, the agreement. That was Attorney Godfrey. Perhaps you should confer with Attorney Godfrey so he clarify what his recommendation was, because I believe the parties adopted and accepted the recommendation of mediator Godfrey.
Correct, Your Honor, and that's what you stated. You stated Mr. Godfrey has informed the court that the parties have reached an agreement on all outstanding issues with the exception of custody and parenting time and wish to reserve that issue until receipt of Dr. Wooten's custody and parenting time evaluation. Is that correct, Ms. Zagorski? Ms. Zagorski says yes. The court, is that correct, Ms. Kuhn and Mr. Chappell? We say yes. The court says okay. So I mean that was the basis. And now the problem is this judgment has been sitting here and hasn't been entered, and we have Dr. Wooten's report, and I'm waiting to file a motion, and I can't even file a motion, and I don't want to hear opposing counsel then make the argument, well, you've had Dr. Wooten's report now for so long, so it's not a proper change. I mean, this is just all getting so backlogged because the judgment hasn't been entered. And I think the reservation language is very important because that's exactly what we did, Your Honor. And that's what Mr. Godfrey had stated to you. And you asked us that exact question. And we said, yes, Your Honor, that is our agreement. That is our understanding. So I think it's disingenuous to go backwards and say, well, our clients didn't state it. Sure they did. When we questioned them at the end, if this was their agreement, they absolutely did. And when we make a statement to the court stating, yes, this is our agreement, and our clients are right next to us, we've conferred with our clients. And I would think that the clients would bring it to the court's attention if the attorneys aren't being honest and forthright and haven't conferred with the clients and haven't represented properly. The court we know. So I think that the argument that that's not what we agreed on when we affirmatively stated to the court that's what we agreed on is not, it's being made, and it's very clear that the transcript states that we did in fact.
What if the judgment included the following language that custody and parenting time is temporary and without prejudice and reserved until final until receipt of Dr. Wooten's report?
We have the report, Your Honor, already. That's the problem.
Okay. Okay, so does someone, because based on that report, someone wants to have a hearing on custody and parenting time, is that correct?
Yes, I'm going to be
Okay,
filing
why
a
don't we just set a
motion.
hearing then? The parties can get divorced in 2025.
We had the mediation and we agreed to reserve custody and parenting time, Your Honor. So I don't
Okay.
know why.
Okay, let's set it for hearing now. Do we need to set a trial date? I mean, I don't know if we want to talk with Godfrey. I thought there were some parameters, but if there's something new in Dr. Wooten's report, then I guess either party can file a motion. We will conduct a hearing. So should we just schedule a hearing today, sometime in January or February?
I'll be filing a motion to release the report to another expert. So I need to get that motion to you. My intent was to get that motion filed once this judgment of divorce was in.
Okay, well, if we can't resolve this issue, we cannot enter the judgment of divorce. I thought the parties wanted to be divorced in 2024. If you want, I'll give you a hearing date, and we'll address at a hearing date for a couple of days of a trial. You can bring in all your, if you want to depose Wooten, if you'll appear for a trial, and we can put some finality to this issue of custody and parenting time. I thought the parties, this court's opinion, the parties should share joint legal custody. Don't worry about physical, it's just joint legal with parenting time. I have not read the full transcript, so I don't even know what the issue was, so I'm not really prepared to address that. I don't recall exactly what the agreement was with the parties relative to custody and parenting time on a temporary basis.
They do a 2-2-3, Judge, and they have been since June of 2023.
So it's just a parenting time issue then. Unless there's something new that's been brought to the party's attention by Dr. Wooten. One party's got some psychological issues or problems.
There's some issues with Dr. Wooten's report, Your Honor, and the motion is requesting the release of the report to Dr. Gunsberg, who is an expert, who's going to be reviewing the report. She would be our expert. And I'm sure Ms. Zagorski is going to use Dr. Wooten. I'm assuming.
I hate to see the parties continue to incur significant expense And it sounds like the 223 has been working. And that was a temporary arrangement. Is that correct? It was a joint legal with a 223 parenting time schedule. Is that what the
Yes.
agreement provided
Yes.
for?
Back in June of 2023, Judge, we did a 223 schedule, joint legal, joint physical.
Your Honor, there's been ongoing issues with respect to what's occurring with the minor child. And
I don't know of any. My client
Yeah.
doesn't know of any.
the minor child has ongoing play therapy as well, Your Honor.
That was agreed to. I think my
Yeah.
client requested it. It's been very successful and effective.
Well, we debate there's things occurring that we believe bear on custody as well, Your Honor.
Judge, my
Okay,
client
so you
is
can
gonna
file a
be-
motion then, Mr. Chappell? You file a motion to modify custody?
Well, that's where, but again, as Ms. Kuhn indicated, we will have an expert witness, but we need to have that report released. I mean, I suppose if we could agree, if everyone would agree to to a stipulation that we could file after the hearing today to have the report released, that would expedite it.
This is the first I'm hearing of it, Judge, and I would ask you to remember this when you consider my request for attorney fees. My client just wants to be divorced and he wants his child to be healthy and happy.
Can we accomplish entering the judgment and then reserving your right to file a motion to modify, Mr. Chappell?
Yeah, we believe, obviously, we believe it's important to have the reservation language that we agreed upon in the judgment.
It wasn't agreed upon. It was the judge's language. The parties never assented to it. I would propose this. We do temporary and without prejudice, and either party's right to file a motion is reserved. How's
How about
that?
that seems to cover Mr. Chappell. Repeat that
No.
again, Mr. Gorski, that the custody parent time be temporary without prejudice.
Either parent, either party's right to file a motion to modify it is reserved.
Well, what's wrong with the language? I mean, here's what we have, Judge. Okay. I mean, it's a matter of where it's placed. The parties, what we've proposed is the parties agree that the issue of custody and parenting time are reserved, period. And then we go on to state that temporarily and pending further order of the court without prejudice, the parties shall share joint legal and joint physical custody of the minor child.
We don't agree that custody and parenting time are reserved, Mr. Chappell.
How are they not reserved?
I will agree that
What have we
file
concluded?
a motion is reserved. I do not agree that we reserved custody and parenting time. I don't agree with that.
What have we concluded in the realm of custody and parenting time, Ms. Zagorski?
That they're temporary and without prejudice. That's what Mr. Godfrey read into the record, and that's what the parties stated they agreed with under oath. They said yes.
And that's what we have in the judgment.
And you also have that it's reserved. And my client never agreed to that. I agreed when the judge asked the question, but that is a different animal than the parties agreeing to that being a part of their judgment of divorce.
Well, I think if you had an issue, it would have been raised at the time the judge asked the question, and you would have said, no, Judge, I don't believe we're reserving it.
Well, I'm sorry, but Mr. Godfrey stated something else. The judge wasn't reading the parties' agreement into the record. The judge was asking a question. I
It's the
didn't bind
predicate.
my client by answering the judge's question. He wasn't under oath and he didn't say yes. I did not bind him to that.
You
It
did
was the
bind him to
predicate.
that.
I
It
did
was
not.
it was the predicate of the agreement.
Well, we don't make agreements based on predicates. We
We sure do.
based on the language on the record.
Where
That
the
is
court,
language.
the court would agree this court's use of the word reserve was perhaps inappropriate. I was just prefacing the commencement of calling this case. But I noticed on page 5, when the court asked Mr. Godfrey to state here in the record, he first of all starts out stating on page 5, temporarily and pending further order of the court and without prejudice, the parties would share joint legal and joint physical custody. So that is the language that the court will adopt in this judgment. We don't need to put the word reserved. If the court has no objection to Mr. Gorski, including that additional language about the parties' right to modify custody and parenting time is reserved. I don't know. I didn't write down exactly what you suggested, Mr. Gorski, but that gives them a little bit of opening.
Yeah, Judge, I don't intend to file a motion, and this court has jurisdiction over the parties. If they believe that custody and parenting time are properly changed, they'll let you know how and why.
Your Honor, then we don't have an agreement because Mr. Godfrey spoke to you, told you that we were doing this, we were reserving custody and parenting time. When we mediated, we were not going to do anything different with the custody and parenting time during mediation because we didn't have the report. Now that we have the report, there are issues. There are continuing issues. We did not agree that we would just say it's just temporarily and without prejudice. We wanted the issues reserved.
In other words, Mr. Godfrey never used the word reserve, but in any event, what if I get Mr. Godfrey on the phone right now? Do you have a few minutes? See if he's available to zoom in?
Yes.
Hi, Tammy. Mark Braunlich is still available. Yeah, I just wonder if you can zoom in. I got the parties in court relative to the Mansick and DeVoot matter. Kim Kuhn, Eric Chappell, Maria Zagorski, trying to finalize some language in the judgment. And I thought if by chance he was available and he could zoom in, and he perhaps could join the discussion. Okay, but yeah, when he can finish it. Yeah, that'd be great if he could. All right, thank you. Thank you. All right, bye. Bye. Mr. Godfrey's on the phone, but someone's gonna hand him a note and they think he'll be available to join in on the Zoom. While I'm waiting for Mr. Godfrey, Mr. Chappell also suggested, or somebody suggested pages, now at 5, but 17, 18, and 19 of the transcript also addressed the issue.
Yeah, I think those are all financial issues, Your Honor.
Okay.
If I could, while everyone is on the line, we knew that apparently something was happening at 3:15 with the court, Your Honor. We were concerned about Zoom, but there was one other issue I'd like to raise. It's a small issue. On page 8, Maria, under personal property, the parties had established a date, Your Honor, by which they would provide Attorney Godfrey with any lists regarding personal property. We extended the other dates that relied upon the judgment being entered. I think that date should be extended as well. Maybe we give them like 30 days after the entry or something.
It already was. Kim made that change already and I approved
Okay,
it.
all right. It wasn't on mine, so.
And you've made that, so we're working off the judgment that Ms. Gorski prepared?
Yeah.
Well, we were working off of the first objected judgment, the one that Kim prepared in response to my judgment. And now there's a third one, which changed things again. So it's getting a little confusing, Judge.
We have that if the parties are unable to agree as to the division of their personal property, they shall request an arbitration with William Godfrey on or before January 31, 2025.
I did send you the transcript, Bill. Tammy has it.
Right. For the record, Attorney William and Mediator Godfrey is present. Thank you, Mr. Godfrey, for short notice of zooming in. And the matter is before the court this afternoon on the defendant's objection to entry of the proposed judgment. Mr. Gorski is present representing the plaintiff, of course, and Ms. Kuhn and Mr. Chappell are present representing the defendant, Rebecca DeVoot. And the issue appears to be they have received Dr. Wooten's report. We may be having a motion filed relative to custody and parenting time. The issue is that Ms. Gorski, your language on page 5 of the transcript, you have a copy of that. You indicated that temporarily and pending further order of the court and without prejudice, the parties shall share joint legal and joint physical custody.
My notes, Judge, indicate that the custody arrangement is, quote, temporary, close quote, and, quote, without prejudice, close quote, to either party. I can indicate the reason why was we had not yet received Dr. Walton's report. And we had adjourned, I mean, this was our third mediation with the parties, and no one could give me an idea when we would end up with that report. So, my thought process was, when you get the report, file whatever actions you need to do dealing with the custody matters.
Your Honor, if I may, Bill, do you have a copy of the transcript?
Tammy is not. I mean,
Okay, I understand. I mean, because there's I know, Your Honor, you referred him to page 5, but when we came into court, the issue, I'll wait for him to come back. It was our intention to reserve the issue of custody and parenting time. And that was the first thing that was addressed when we appeared in court. And I'll just read it since you don't have it. Page line 20, the court, Mr. Godfrey has informed the court that the parties have reached an agreement on all outstanding issues with the exception of custody and parenting, and wish to reserve that issue until receipt of Dr. Wooten's custody and parenting time evaluation. And then both counsel, Ms. Zagorski and myself, were asked if that was correct, and we both indicated correct. We believe it is important to include language in the judgment of divorce, which indicates our understanding that the issue of custody and parenting time was being reserved. We have no issue saying that, we have no issue saying that that we put the temporary language in there. But on page, from our perspective, that was the predicate of the agreement, is that the parties were reserving the issue of parenting time and custody.
And Mr. Godfrey, I have no idea the content of your conversation with the court when you called the judge and told him that we had an agreement and we would be putting it on the record. I don't know whether you said that custody and parenting time were going to be reserved or not, but the judge stated that was his understanding. And your letter to us and the transcript reflect you stating that it was temporary and without prejudice and not reserved.
That's correct. Mr. Godfrey and the court did not discuss anything in detail. The court, perhaps, as I stated before, perhaps inappropriately used the word reserved. I just knew that it was not a final agreement on custody and parenting time. That's all I was trying to say. So I perhaps inappropriately used the words. Mr. Godfrey did not use the word reserved, Mr. Chappell or Ms. Kuhn. So, Mr. Godfrey, that seems to be the rub here in the issue.
Well, Judge, I think on page 5, I indicated that if they wanted to bring up topics or issues with the children going back 2 years, 3 years, or whatever, they could, which I don't know what I mean, I wish I had Wooten's report, or if the parties were disagreeing with Wooten's report, but we had been pushing it out. I don't know what else to do in those circumstances.
We just want to make it clear that we're not precluded from raising any issues whatsoever because none of us had that report. We don't want there to be an argument made down the road that when this motion gets filed, that there's some preclusive effect from the judgment. That's why we felt the reservation language was important.
I've agreed to language that says that. It was included in my original judgment, which says that the judgment shall not operate as a bar to issues that preceded it.
In addition, though, the concern is that I also don't want the argument, and this is why I wanted it reserved as well, that the parties have been exercising this parenting time arrangement for a long time now, and that precludes any argument that a motion to modify or to change is not appropriate. There is case law that does allow for the parties to have temporary agreements, reservations by agreements, and the court has upheld those. I have case law. My concern is I don't want to have an argument or see an motion from opposing counsel. This arrangement's been going on since 2023, and no court, you just need to deny this without an evidentiary hearing because this is what the parties have done. We don't want to be denied an evidentiary hearing. That's why reserving it was important. That's why when the court stated, okay, it's reserved, We were good with it. That was our understanding.
What about the language that custody and parenting time is temporary and without prejudice, reserving the right to seek modification upon receipt of Dr. Wooten's report?
No objection.
Reserving the right, but
Reserving the
then,
right to seek modification upon receipt of Dr. Wooten's report.
So now we have the court speaks through its order. So now we have an issue where someone can raise that, the reservation is the report. And we made these decisions. And so what can come in, what can't come in?
But the reservation was the report, Mr. Chappell.
It is not. You got to look at page 5. You have to look at page 5. Bill made it very clear that we could bring in anything.
Bring up matters or actions or acts that they think is important that predates any part of that agreement.
Correct.
there is case law out there that states a temporary arrangement can just basically become the permanent arrangement. That's what I'm trying to avoid. I don't want to have an issue on appeal because the language in the judgment didn't encompass what the agreement was. The agreement was that once we got the report and we looked at the report, if somebody wanted to file a motion, they absolutely could, and it wouldn't bar any evidentiary hearing, and that the longstanding arrangement of the parties would not in any way persuade the court to continue that. That's why we wanted everything to just be reserved. So that's my issue, Your Honor. If it goes up on appeal, that would be the issue. That's why we wanted everything reserved. We talked about no proper cause, no change in circumstances, the ability to automatically have an evidentiary hearing on this matter, not convincing you that the longstanding arrangement isn't appropriate. It was to be able to go to hearing if necessary. So that's what I'm concerned about. And that's why I think the language in the judgment needs to ensure that the parties have that ability. Because yes, I am filing a motion. Yes, I'm going to be asking to release the report as well as Dr. Wooten's notes, his test results, everything to our expert.
But here's the problem, Judge, I think she just put it on the head of a pin. The bottom line is that they want a custody hearing. But what we agreed is found on page 5 at line 15. The parties would stipulate and agree that Dr. Wooten's report would be sufficient for any party. Not anything, Dr. Wooten's report. That was the agreement. And I now understand what the controversy is here, is that counsel is trying to get in the back door and create an agreement where none existed. We agreed that Dr. Wooten's report would be the basis, not Dr. somebody else, not their expert, Dr. Wooten.
So you're ignoring the rest of the language on page 5. And Bill even said that if we can go back 2 years, 3 years, they can bring up anything they want involving parenting time, custody, etc. So, I mean, that this is the very issue that we are concerned about, Your Honor, because there will be an attempt to limit it. And it's very clear from what was put on the record that everything was open. Everything.
Neither party is prevented from bringing up those matters in the context of Dr. Wooten's report. That's what it says.
It does not say that.
Does not.
Start at line 15 and read to line 20. No, read to line.
So if they want to go back 2 years, 3 years, they can bring up anything they want involving parenting time, custody, obviously subject to what weight the court gives it.
But Dr.
Wooten's report that we just don't have, and frankly, Judge, I'm tired of waiting for it. So we're going forward with what we've got. No one could have agreed that Dr. Wooten's report was the only act because we didn't have it. There's no way that anyone was limited from it because we didn't have it.
Dr. Wooten's report would be sufficient for any party to seek a change in parenting time. Dr. Wooten's report, that's what we were waiting for. That is the nexus to a change in custody.
We did not have Dr. Wooten's report. We didn't know what it would state. As Mr. Godfrey had stated, we moved forward and reserved issues, made the custody and parenting time as temporary as we could because we didn't know what we were doing with custody and parenting time. We did not have Dr. Wooten's report. We have Dr. Wooten's report. We don't have a judgment entered. I don't want an argument that Wooten's report was the end all of it. In fact, I have to have an expert to refute or to look at Dr. Wooten's report because Dr. Wooten, I'm sure Ms. Zagorski's going to put him on the stand. It's common sense, Judge. If there's an issue with the report, if Dr. Wooten did not properly do something, or if there are issues and concerns that things weren't done, the court needs to hear it. And we didn't have that information at the time we mediated custody and parenting time, and that's why we wanted it reserved, temporary, without prejudice, with the ability to have an evidentiary hearing. Once we received the report, we were able to evaluate it, figure out what it did or didn't do, if there are any issues, and there are issues, as well as other issues, Your Honor. That's the also, as Mr. Chappell had stated, that's why we didn't just limit it to Dr. Wooten's report. There are other issues going back. We kept it wide open.
I think we're better off to set a trial. Let's just set a custody parenting time trial. Obviously, if this 223 schedule has been going on for the last year and a half, again, we'll give you a hearing, even though there may not be a sufficient change of circumstances under Vodvarka, but it seems to be working to the court. There's been a lot of issues. Obviously, that Wooten report was meant to assist the parties and reach their own agreement. But obviously, if they cannot, let's just set a custody and divorce trial, and we will hold off entering the judgment of divorce till sometime in 2025. Mr. Godfrey, do you have any suggestions? I don't want to waste any more of your time. I know you've spent 3 mediation sessions with the parties, and I thought we had a framework of an agreement, but we don't. And I guess rather than going back and forth, let's just set a custody and parenting time trial. Ms. Kuhn, you want to hire another expert? Is that correct?
Yes, Your Honor. And I need to release the report, and I was going to file the motion with the order allowing Dr. Gunsberg to get the raw data for the testing results, the notes, all of the documentation that had been provided to Dr. Wooten, and to release the report to Dr. Gunsberg.
The parties going to perhaps reconcile. They don't want to get divorced. I know the intent was to get divorced in 2024 for tax reasons. I don't know if there was tax reasons, other reasons why they wanted to conclude this matter this year.
They've been filing separate anyway, Your Honor, and they're not reconciling.
All right. Do you want to just, we'll adjourn this matter without date. Ms. Kuhn, if you want to then go ahead and file your motion, and then at that time, Ms. Zagorski can respond if she gets involved in the case, and then at that time, the court can set the trial date on the issue of custody and parenting time. Until then, the joint physical with 223 will continue until further order of the court.
Thank you, Your Honor.
Thank you, Judge.
Anything further, Mr. Godfrey? Do you have any suggestions? I don't know. I don't think there's any purpose served with you meeting with parties any further.
I have not seen Dr. Wooten's report, Judge, so I don't know if there's anything I can do after seeing that to help the parties.
All right. Anything further then this afternoon, Ms. Zagorski, Mr. Chappell, Ms. Kuhn? I'm open to any suggestions.
Not at this time, Your Honor. Thank you.
Thank you, Judge.
All right. Thank you, Mr. Godfrey, for zooming in at short notice. The court appreciates it.
Thank you.
Yep. Thank you, Bill.
Thank you.
Okay. Oh boy.